responsibly can settle and dispose of legitimate injury claims with a minimum of cost, a minimum of delay, in the best interest of the public, and in the long run in the best interest of society generally. Thank you very much, Jim. Our next speaker is another Jim. It's Jim Flaherty, who's a senior partner with Gilbert Wright and Flaherty, a leading litigation law firm that does mostly insurance work. Jim is a graduate of Princeton University and, of course, Osgood Law School. He was called to the bar in 1975. He's a member of the executive committee of the insurance law section of the Canadian Bar Association and is a member of the alternate dispute resolution committee of the Canadian Bar and as well the no-fault committee of the Canadian Bar. Jim had some input into the drafting of the SEF 44 endorsement, the one Mr. Justice Coulter Osborne referred to as being somewhat of a mystery and one he would like to hear discussed. It's one that shouldn't be a mystery to anyone at this stage, but I recall when it first came out that it was about 1 page long, and attached to it were 14 pages of explanatory notes. To try and throw some light on what it really means and how it differs from SEF 42 and how life is going to be much more comfortable with SEF 44, Jim has agreed to come and help us. Jim Flaherty.
Am I taller than this podium, I hope? Yes, I am. Good. The reason I get to talk about SEF 42 and 44 today, I think, is because I missed the meeting when the assignments were handed out. It's certainly perhaps one of the driest subjects that we're going to talk about today, but it is important when you get into larger claims, and particularly dealing with the SEF 44, which is the endorsement that most of us are dealing with these days. The SEF, by the way, to those who don't know, means Standard Endorsement Form, to take away the mystery of what those initials are. Mr. Justice Corey in the Wigle and Allstate case, which is referred to the 42 endorsement as the endorsement to the General Motor Vehicle Policy of Insurance, which has the romantic title of SEF 42. The committee in 1984 that looked at the 42 and tried to redraft the 44, I think it is fair to say was trying to bring the 42 back to what was originally intended and to try to correct the problem that was perceived to arise out of the Borland case. There's no question that the 44 is much more restrictive in its coverage than the 42, and that is intentional. At least more restrictive than the way the 42 was interpreted by the courts. Some people don't refer to it as the family protection endorsement, which is the name given to the 44. Some call it the family non-protection endorsement, which may be a little unfair because there are some situations in which I think you'll find the 44 quite helpful if you do plaintiff's work. Before I get into the 44, I just want to comment briefly about the persisting ongoing SEF 42 litigation, of which there is still some. In the paper, which I think is in the H section, pages 18 to 22, I reviewed some of the pending cases. Most of you would be familiar with the Borland decision, which stands for the proposition, at least this proposition, that where there are multiple claimants, the policies with SEF 42 endorsements are simply stacked one upon the other, and the claimant's judgments are prorated until such time as the available insurance is exhausted. And the Court of Appeal in Borland used each individual claimant as the basis from which to stack. Before Borland, there was a decision of Mr. Justice Gray in a case called Peltier, and it's in the footnotes, the citation. The Peltier decision was not specifically overruled by the Court of Appeal in Borland, but some people, I think, fairly say that the Peltier decision is inconsistent with Borland. That has been followed since Borland by two decisions of Mr. Justice Donnelly, the better-known one being Pagliarella. Mr. Justice Donnelly took a different course than the Court of Appeal in Borland, holding that the total of the recoveries under the SCF 42 cannot exceed the aggregate limit of the 42. So he is in effect capping the 42, which may or may not be what the Court of Appeal meant to do in Borland, except in cases of multiple claimants. There's the Pagliara case, the decision of Mr. Justice Gray in Peltier, and then two cases to the contrary, Lossing, Mr. Justice Rosenberg, and Medeiros, Mr. Justice Sutherland. There may be others. In both the Lossing and Medeiros cases, the trial judges felt bound by Borland, although Mr. Justice Sutherland expressed some sympathy for the reasoning of Mr. Justice Donnelly. The end result of all this is that we don't know the answer, the final answer on stacking. I've spoken to the counsel involved in the Pagliara case, and I'm told that on Valentine's Day, February 14th, which is a romantic day, that the Court of Appeal will begin considering for 3 days, apparently, the reconciliation of Borland, Pagliara, Lossing, and Medeiros. So that's the stacking issue, which is still outstanding under SCF 42. From what I know, most insurers are relying on Pagliara presently and are not stacking their 42 limits, waiting to hear what the Court of Appeal will do with Pagliara. Moving from the 42 to the 44, at page 3 of the paper, you'll find the relevant dates, which are worthwhile noting. The 44 was drafted in 1984 and was offered beginning February 1, 1985. The SCF 42 was still available then up to the end of January 1985, so that theoretically and practically, I suppose, if a person had a one-year auto policy, you could have someone with a 42 attached to a standard auto policy up to the end of January 86. But after that time, we're dealing strictly with the 44. I can't help you with case law on the SCF 44 because I'm not aware of any yet. But what I can do is go through, and what I plan to do, some of the basic concepts of the 44, use some examples because it's difficult to try to understand the 44 without examples, and hopefully I'll give you a scheme that you can follow when you're reading it. The insurance people that I know tell me every time they get a 44 question, they have to go back to the endorsement and try to follow it through. And what I'll suggest to you is a way which I think is a little bit quicker of going through it when you're faced with a underinsured problem. First of all, the 42 and the 44 are not part of the standard auto policy. This is optional coverage. A consumer may purchase it and an insurer may offer it. The 42, of course, can no longer be offered, and the insured will be asked to pay a premium for it. The reason for the coverage is to top up, if I may use that expression. It was designed for the situation where you or I buy a policy with $1 million, Section A, third-party liability limits, and we're unfortunate enough to be injured seriously or killed by someone with minimum limits, or at least limits lower to our own. And the initial concept was simply to top up those limits so that you, having paid a premium for your $1 million policy limits, being hit by someone with minimum limits, would be able to top up from the 200 to with the additional 800 to bring yourself to your own Section A policy limits of $1 million. That concept was distorted by the litigation that arose out of SCF 42, and decisions, including Borland. That's not to criticize the decisions that were made. I think most people agree that the SEF 42 had real drafting problems and ambiguities. The scheme I suggest, if you want to analyze the 44, and I think it's at page J19 of the book, it is typed in the smallest print imaginable, I think, to try to get it onto 2 pages. If you have one of those photocopiers that blows up things, it's a good idea to blow it up. It's difficult to read. First of all, you're not going to look at the 44 unless you have a serious case in which your client's injuries may have a value in excess of $200, the minimum, $200,000, the minimum limits. But you also might have to look at it if you're dealing with a case with multiple claimants who in the aggregate may exceed the policy limits, each one of their injuries perhaps not being that serious. The scheme of the endorsement is, first of all, to look at Section 2, which is the operational section, the insuring agreement. The indemnity provided there refers to the insurer's obligation to indemnify each eligible claimant, and we'll come back to that. That's a magic phrase. And then later on, in respect of bodily injury or death sustained by an insured person. And again, insured person is a magic phrase. After you go to Section 2, go back to Section 1. That's where the definitions are. And that's where you'll look at the definitions of insured person and eligible claimant. You may find out even at that point, after going to Section 2 and Section 1, that you can stop there because your client is not eligible or an insured person. If you've got that far and your client is still eligible, go then to Sections 4 and 5 of the endorsement. And Sections 4 and 5 are the sections that are to be used to determine the amount payable under the 44. Even if you have an amount payable under the 44, go back to Section 3, because that's sort of the catch-22. There may not be an amount available under the 44. And I make the distinction between available and payable. If you have a situation where there is more than one applicable SEF 44, which is quite possible, and I'll come back to that, then you have to go to Sections 7, and if there's more than one automobile on the policy, Section 11. So the scheme I'm suggesting to you is go from Section 2 to Section 1 to 4 and 5 to 3, and then to 7 and 11 if you're in a situation with multiple coverages. To deal with some of the basic definitions, and I'm not going to spend much time on this because there's too much to cover. The magic words insured person are defined in Section 1. You must have damages in respect of bodily injury or death sustained by an insured person pursuant to the insuring agreement, which is Section 2. You'll note in the definition of insured person, and this is a change, that the concept is that the endorsement follows the insured from vehicle to vehicle, as opposed to the endorsement following the insured vehicle. You can see that from the definition. Insureds include the named insured, his or her spouse, and dependent relatives of either. And I'll point out the either there because you may have dependent relatives who are not dependent relatives of the injured person, but rather of the injured person's spouse, and they would still fall within the class. Once you're finished with insured persons, then you go to eligible claimants, which is in Section 1C of the definitions. It repeats the insured person definition and then goes on to specifically include FLA claimants in Section 1C2. That section is also designed to include other representative plaintiffs such as executors and trustees making claims, for example, under the Trustee Act for pain and suffering sustained by a person before death. There's one item that I think has been and will become controversial under the 44. While FLA claimants are in, unidentified vehicles, unidentified owners and operators are out. They are specifically excluded in section 1E of the definitions. As I understand it, and I'm not an authority on this, the concern with excluding unidentified vehicles was that in underinsured litigation, the underinsured carrier may not have notice of the claim until a long time down the road. There's sort of a rolling limitation period in this endorsement, which I'll come back to, but it could be years down the road before a plaintiff's counsel or the plaintiff realizes that their claim is underinsured. And there was the concern of prejudice to the underinsured carrier and created claims being presented to underinsured carriers. I'm a little bit concerned about the unidentified exclusion because I think it might surprise one of us if we went out and purchased a policy with $1 million limits and then were hit by a hit-and-run driver and seriously injured to find out that our only recourse is $200,000 under the underinsured motorist carrier because there is no coverage under the 44. And I read that together with Mr. Justice Corey's comments concerning reasonable expectations of consumers in standard form contracts in the Wigle case. There is a cap on recovery under the SEF 44. Here I'm looking at section 3 of the endorsement and pages 10 to 12 of the paper. You need to do a comparison of policy limits in order to determine whether there is an amount available under a 44. For example, in cases involving a number of vehicles and contributory negligence by a number of insured persons, you may well not have any sums available under a 44 coverage. There's a brief example at page 11, which I'll just run through, a very simple example. If A is operating his own vehicle and he's hit by B, the accident is B's fault, he's 100% liable. A's policy limits, his Section A and SEF 44 limits, and they're usually the same, are $500,000. The liable driver's policy limits, Section A, are $500,000. So the two limits are equal. There is no amount available under the SEF 44, regardless of the severity of the injury sustained, because there is no, and I'm quoting the Section 3 now, there is no amount by which the family protection coverage exceeds the total of all limits of motor vehicle liability insurance of the inadequately insured motorist. So if the SEF 44 limits are equal to or lower than or do not exceed the other policies put together, there is no money available under that SEF 44. I'll skip that. This example is a little bit more complicated, and if you have a pencil, you might want to follow along. Let's assume a multi-vehicle accident, 3 vehicles. A is operating his own vehicle with a policy with SEF 44 Section A limits of $1 million. His vehicle is struck by B's vehicle, and it's also struck by C's vehicle. Let's say B and C have similar policies. B's Section A limits are $500,000. C's Section A limits are $500,000. So the third-party liability Section A limits are $1 million. A, who is the injured person, not at fault, innocent plaintiff, has an SEF 44 of $1 million. Let's assume that both B and C are contributorily negligent. If each of them is contributorily negligent, then the total of their Section A limits, 500 plus 500 is 1 million, is the same as the SEF 44 on A that A has on his policy. So there's no amount payable. There's no amount that can be payable pursuant to Section 3 of the endorsement under the SEF 44. But this raises a practical problem. If you're sitting looking at a case that may or may not have a small piece of contributory negligence on someone else, use the same facts and let's say the case goes to trial. and one of them, let's say C, is held 100% liable. The same assessment of damages, $1 million, is the value of the plaintiff's case. The limits for C, who has been found 100% liable, are $500,000. So A, the injured person, recovers under the Section A policy $500,000. Well, he's short $500,000 on his assessment, which he would not have been had there been a split of liability. At that point, he can go to his SEF 44 to top up to his $1 million. So in that example, as long as his assessment is $1 million, he recovers $500,000 under his SEF 44 cover. You can see in liability situations involving multiple vehicles and serious injuries and death that some of these types of claims may go on for a very long time and may require a liability determination before the SEF 44 insurer is going to be willing to pay anything. Quickly, there are certain types of damages that an attempt was made to exclude them under SEF 44. And I'm looking now at Section 5 of the endorsement. Well, first of all, in the insuring agreement, compensatory damages are mentioned. That's in Section 2. Added to that is the more specific language of Section 5D, which purports to exclude punitive damages, exemplary damages, aggravated damages, and that was intentional wording to try to make it clear that those damages were considered not to be compensatory damages. This may be another problem with SEF 44 in a case where aggravated damages might be appropriate. And I'll just mention the description of Mr. Justice Robbins in the libel and slander case, Walker and CFTO, decided last year, where he described aggravated damages as compensatory in nature. And I think we might run into a problem with the interpretation of the insuring agreement referring to compensatory damages if his lordship's definition holds. Prejudgment interest, as against the SEF 44 carrier, is excluded until notice is given. And the notice requirement is in Section A1. That may be very important in a very large claim with not much money available from third-party liability policies, that notice be given early to start prejudgment interest accruing against the SEF 44 carrier. And I'm sure all of you are familiar that under Section A of the policy, prejudgment interest is payable by the Section A insurer only up to the policy limits and not beyond. And in a large case, you could have substantial prejudgment interest accruing. Costs are excluded from collection from the SEF 44 insurer, but that's not a great loss because you'll collect your costs from the tort insurer if you're acting for a plaintiff. OHIP subrogated interest, that was mentioned earlier this morning. I think that OHIP probably will not be subrogated and probably is not subrogated under SEF 44 for the reasons that I expressed on page 9. Still dealing with how you calculate the entitlement under the SEF 44 and turning to Section 4. And this is really arithmetic at this stage. There are two types of two types of recoveries that are deemed, or that the SEF 44 is excess to. So you have to look first of all at actual sums recovered by the eligible claimant. That is there, among other things, to avoid Borelli and Flanagan, to avoid double recovery by an injured person of so-called collateral benefits. It's designed to include even gratuitous payments from a generous employer, for example. The purpose of it is to look at exactly how much the person has actually recovered. The second test in the same section is dealing with entitlement. The person, the eligible claimant, may not have actually received this money but may be entitled to it. And that was designed to encourage claimants and their lawyers to pursue the claimant's entitlements. If he's entitled to somebody, to force them to get on with it and collect it, which will reduce the exposure of the SEF 44 insurer, but only to that particular eligible claimant. And this is not draconian, because what's happening, since there are no priorities between claimants under the SEF 44, unlike the 42, if you're reducing the funds available to one eligible claimant, the pool is greater for those other eligible claimants who may be sharing pro rata. In Section 4B, there is a list that I won't go through of entitlements that the SEF 44 insurer is entitled to look at and deduct. One of them caused me some concern, and my thinking isn't very clear on this, but I'll just mention it, and that's item 6, any automobile accident benefits plan applicable in the jurisdiction. And I suppose in Ontario that means Section B benefits. I have a concern that a tort insurer will be deducting Section B benefits pursuant to Section 237 of the Insurance Act, and that in fact a double deduction may be happening if the SEF 44 insurer can do that. I haven't thought it all the way through, but it's just something that goes through my mind when I see Section B benefits being potentially deducted twice. Sharing SEF 44 funds. As I mentioned, there are no priorities among claimants. It's anticipated that prorating will be necessary, and that is prescribed in Section 4C. So if there's only so much SEF 44 money, the claims are prorated the same way as they are under Section A claims where the limits are inadequate. Multiple coverages, and this can happen quite frequently given the definitions of eligible claimant. If you're acting for someone who's seriously injured or dead, and there's not much in the way of Section A limits out there to compensate your client, you're going to have to search around for SEF 44s. Your client may have one, his wife may have them. If there's more than one car in the family, they may have one. He may be a dependent relative within the definition, and there may be one SEF 44. If there is more than one, then you have to look at Section 7, which will tell you whether that additional SEF 44 is first loss or excess. And then you go back to Section 3 to see how those monies are distributed. Am I going on too long? Okay. This example is a little bit long, but it deals with multiple coverages, and it may be of some use. Let's assume A is an insured person injured in a motor vehicle accident caused by B. A has SCF 44 limits of $500,000. B has minimum limits $200,000 under Section A. And let's assume A is seriously hurt and his damages are worth $1 million. He's going to recover $200,000 from B's Section A insurer, the minimum limits under Section A, plus costs, because that insurer has to pay the costs. He's got a $500,000 SEF 44. He will recover the difference between the 200 and the 500, that is 300, from the SEF 44 carrier. But his damages are $1 million, so far he's got, from his own SEF 44, $300,000. From a Section A policy of the tortfeasor, $200,000, he has a shortfall of $500,000. But you shouldn't stop there if you're searching out other SEF 44s. It's possible that A may also be a dependent relative of someone who has another SEF 44. Let's say he is, and let's say that other SEF 44 has $1 million limits. In that situation, you go back to Section 3, and assuming that the additional 44 is an excess policy under Section 7, then the calculations would go like this: $1 million assessment of damages, $200,000 from the tort insurer, leaving a balance of $800,000, $300,000 from the first loss SEF 44 carrier, leaving a balance of $500,000. And since the damages were $1 million, there's $500,000 left from the excess SEF 44 carrier. So that in this example, the injured person using tort limits and 2 sets of SEF 44 limits is fully compensated. He would not be fully compensated, admittedly, if his damages were assessed at more than $1 million using this example. There was some concern, a couple of small points about the SEF 44 insurer being a party. There was some litigation about that under SEF 42. I dealt with that at page 23, and I think it's fair to conclude that SEF 44 insurers will commonly be parties in tort litigation in serious claims. Subrogation and assignment are dealt with in the endorsement. And last of all, I'd like to talk to you briefly, and I may be wrong about this, but what I'd suggest to you if you're dealing with claims that potentially may have SEF 44 carriers involved. And I dealt with this at pages 26 to 30 of the paper. The procedural requirements are in section 6. The first one is the prompt written notice requirement. But that's a double-edged sword. You say, well, I'll just give prompt written notice anytime I think a claim may go over the Section 8 limits. Realize as soon as you do that you're starting the limitation period running, because you're not going to be able to say 3 years later to this SEF 44 carrier, I did not have notice that this claim might exceed the SEF, the Section A liability limits. It seems to me that once a lawyer or a client has given notice, that limitation period is running. I think the short answer to that is treat the SEF 44 limitation period just like you treat the Highway Traffic Act limitation period. Call it 2 years. It's always 2 years. Give notice and issue your proceeding against the tortfeasor and against the SEF 44 carriers, and maybe more than one, within the 2-year period. Also remember that until you give notice, prejudgment interest is not going to run against the SEF 44 carrier. And looking at the limitation period in Section 6A1, note that it's talking about the minimum limits. It's not saying to the claimant or his legal representative, when did you know that your client's claim would not be capable of being satisfied by the defendant, tortfeasor's third-party liability limits, which might be $500,000 or $1 million. It says, when did you know, or ought to have known, that the claims were potentially excess $200,000? And note also that the limitation provision does not talk about liability. Your client may have a terrible liability case, but if it might be worth more than $200,000, you should give prompt written notice. Well, I hope these comments are of some help, and we'll see. If I had stood here in 1981 or 2 and talked about SEF 42, I'm sure I would have been proved wrong by most of the subsequent cases, and we'll see what happens with the 44. Thanks.
Thanks, Jim. I'm sure that we all hope we don't run into the problems with SEF 44 that we did with SEF 42. The best guess is that we won't, but only time will tell. Our next speaker is Jim Keaney. Jim is from the Ottawa Valley. He, because of either very high IQ or because he could play hockey, or perhaps both, he ended up at Cornell University, and after graduation went to the University of Ottawa, where he got his degree in law, and has since then practiced in Toronto, and more recently as a partner with our firm. He is very good at volunteering. He volunteered to organize this program, and really he's responsible for all the work that's been done. And he further, I'm sure you will understand, volunteered to speak on Section C and also any other provisions of the Act that weren't covered by anyone else. Will you please welcome Jim Keaney?
Thank you, Wendell. So that Wendell doesn't mislead any of you, I didn't get to Cornell because of either of those two things or any of those two things. I had no talent in either one. Before I get started on the topic that I've been asked to speak about, I want to take advantage and follow up, if I may, for just a moment or two, the comments made by Mr. Justice Osborne at lunch. I had no idea that he was going to be speaking on that at all, but I was very gratified when he did. I'm the chairman of the insurance law section of the CBAO, and I've been involved in the committee that he referred to, that the committee that the ubiquitous Ken Howie is one of the driving forces on. It's a joint committee made up of representatives from a number of organizations, the Advocate Society, the county and district presidents, the benchers of the Law Society, and representatives from the Canadian Bar Association. We've been dealing with matters of court reform and case management. I don't believe that there has been an accurate count taken, but I surmise that at least half of the cases that appear on trial lists are cases in which the insurer is the real party. As best I can determine, insurers are the single largest users of the civil litigation system, and I think it's important that insurers get some input and have an opportunity to be heard respecting matters of court reform. It's of vital interest to the insurance industry and therefore to the insurance bar. We're just at the point where we are starting to work on a model for a system of case management. And some of you who may be members of the insurance law section will have received something from me recently, and those of you who haven't, I invite any of you to let me have the benefit of your comment and your input so that I can bring that to our discussions about the model. I'd like to see us come up with one that most appropriately suits the needs of the insurance industry and the insurance bar. Sorry for doing all that. I couldn't resist the opportunity given by Mr. Justice Osborne. A good trial lawyer will never miss an opening when it's given to him. Now, I don't know what Flaherty was complaining about when he talked about how dry his topic was. His, at least, is one that deals with large cases, and large cases, by their very nature, are interesting ones. I get a topic in which there are really no cases in which it is involved, or indeed, they are only small cases. While it may be less interesting in that respect, it is of no less importance, and therefore is worthy, I think, of some consideration by us. It's likely the case that most lawyers have either not read Section C, have read it perhaps recently, have not read it in any great depth very often, or with anything more than passing interest. When they did read it, the only thing that was retained was the admonition against driving while intoxicated, and that remained only to the extent of causing subsequent confusion in the mind of the lawyer in looking at some other problem, dealing with some other part of the policy, when he says, gee, I thought I saw something in the policy about driving while intoxicated. Because of all of that, Section C needs a look. It's not as dynamic or as exciting as these other parts of the policy, but we should have a view of it. The coverage is optional. You don't have to have it in Ontario. Most of the other things we've been dealing about today are, as you know, mandatory coverages. Given the cost of motor vehicles and the reputations that the body shops have, I'll pass comment on the deservedness of that reputation, but the reputations for the cost of repairs to vehicles, the coverage is certainly prudently obtained. It's not terribly expensive in the context of your whole insurance premium. That is, your premium as it now is, or perhaps as it is about to become. Most everyone who wants the coverage will get what is commonly known as the C&C, collision and comprehensive. Collision meaning the collision and upset subsection, the comprehensive referring to the comprehensive subsection. The other two specified perils and other perils are rarely obtained. Collision and comprehensive will provide coverage for most of those events that might cause damage to your vehicle. A broker friend of mine recently related to me his difficulty in trying to get any quote at all for a client who was looking for specified perils coverage for his brand-new Ferrari. I am told that these Ferraris have a price tag that is in 6 figures, and the first number isn't a 1. This fella didn't think he was going to get any quote at all, and could only speculate as to what the premium might be. You don't need all perils coverage. It may be more than an academic exercise to determine whether a claim that's made under collision comprehensive is made under the collision part or the comprehensive section. The deductibles will almost always be different, and you may have one coverage and not the other. That would be something that should be looked at both by counsel on behalf of his client and by the insurer dealing with the claim. The wording for the collision or upset coverage is straightforward. Basically, you will be indemnified for the cost of the repairs to your vehicle, less your deductible, occasioned by some altercation between your vehicle and someone else's, a lamp post, or the back wall of your garage. For the comprehensive coverage, you'll be indemnified for the cost of the repairs to your vehicle, again, less your deductible. That may be occasioned by, for example, the vandal who scrapes his key down the side of your car, or the jerk in the tight parking garage who lets his door slam into yours. You'll be glad to know that under the comprehensive coverage, those things that are deemed to be part of that coverage include such things as damage from earthquake and riot. The riot may be of particular note depending on what the government does with the recommendations for the rate increases. You are unlikely to have any say in the size of your deductible. The insurer will give you what it gives, although you may be able to trade off a much higher deductible for a slightly decreased premium. In having a look at Section C and preparing to make these comments, I came upon what I believe is a little-known endorsement, but one that I thought was just terrific. Endorsement 43R is a waiver of depreciation. If you don't already have it, if you take nothing else out of here, go to the phones at the end of today's program and call your broker, especially those of you who are doing well enough to have recently purchased vehicles made by, I don't know, Swedish jet manufacturers or minions in the Black Forest, where you've paid the big price. This coverage seems to be well worthwhile. You will get the full replacement cost of your vehicle if it's destroyed or damaged within a certain specified time frame. The one on my policy that I found quite by accident comes with no added premium. So follow it up. The part of Section C that most often requires consideration is the exclusion for damage caused where the insured drives or allows someone else to drive while under the influence of intoxicating liquor or drugs. Please note that that exclusion applies only to Section C claims, that is, only to claims for damage to your own automobile. There is still some confusion, I think, in the minds of too many people that that applies to, for example, third-party claims. There is a similar but not exactly worded exclusion in Section B. Based upon the present wording of the policy, it appears that in order for the insurer to deny a claim under this provision in a Section C claim, the insured must have been convicted of something like improper water skiing or the operation of an unseaworthy vessel. You will know that Mr. Justice Osborne pointed out that the criminal code sections cited in the policy are, by reason of amendments to the criminal code, no longer applicable. Presumably, no matter what amendments to the policy may be contemplated in the near future, presumably this part can get its quick and easy remedy. Now, as I said, Section C claims Section C does not generally result in much by way of claims or litigation that our lawyers have to deal with. The major reason for that is because of a document entitled the Insurance Bureau of Canada Intercompany Settlement Agreement, AKA the fault chart. Now, those of you in the audience who are employed by insurance companies, please don't put your head down on the table and have a snooze just because you might know about the fault chart. I know the lawyers here, at least some of them, are not terribly familiar with it, and I think that should have a look as well. Most insurance companies in Ontario are signatories to the claims agreement. Rule 11 of the agreement sets out the fault chart. That sets out 8 scenarios involving motor vehicle accidents. When you look at them closely, I found it remarkable that those 8 scenarios cover just about any of the physical ways in which a car accident can occur. In order for the fault chart to apply, the insurers of both drivers must be companies that are signatories to the agreement. Both drivers must have collision coverage. It's not in the material before you, but I'll read to you Rule 11 of the agreement. Where damage to a vehicle results from a vehicle-to-vehicle collision on a public thoroughfare or private property, the insurers agree, A, to pay collision deductibles to their own insureds on the basis of the apportionment of liability shown on the driver fault chart for the circumstances therein described, and B, to subrogate against each other on the same basis for the collision damage claim paid by each and for the deductible payable by each. I had an old form of the agreement, and it suggested that claims of this sort are limited to $10,000. I'm not certain that that is the case. That may have been amended since the time I saw it. Percentages are then applied to the various factual situations. For example, as you insurers know, a rear-ending vehicle is 100% at fault. The chart provides that a vehicle turning left at an intersection or a private driveway as another vehicle is overtaking to pass results in 75% being applied to the left-turning vehicle and 25% to the overturning vehicle. All of this is irrespective of any other factors or considerations that enter into it. The lawyers may not look at it that way when they're dealing with the bodily injury claim. There are other extraneous factors, but as far as the damage to the vehicles go, once you have the vehicles in that position, that's all that matters. 5 minutes, he says. I know you don't want to miss any of this. Okay. Now, at the risk of being taken by any of you to make any utterance that is or deemed to be in favor of the dreaded NF word, no fault, I must say that the fault chart, while not exactly a meat chart, I suppose it's more appropriately called a metal chart, it does seem to work very well for the benefit of insureds and insurers alike. It's now, I think, the rare examination for discovery in a bodily injury action where a plaintiff's counsel has to tell you that there is a claim made also for the damage to the vehicle. Now, when this program was in the early stages of its design by Mr. Wigle, in spite of his disclaimer to the contrary, he's the fellow who did all the work, it was contemplated that Section C was hardly worthy of much attention at all and that I should deal with everything else. As the program unfolded, it became clear that Messrs. Webb and Racklin were dealing, as expectedly, so thoroughly with their subjects that the general provisions, definitions, and exclusions and the statutory conditions were each addressed by them insofar as they apply to those sections. Having said that, though, I think there's one area that should be addressed in the statutory conditions, if for no reason other than the amount of litigation that seems to arise around it. And that has to do with termination of the policy. As you know, in Ontario, we have the Compulsory Automobile Insurance Act, 1979. You have to have minimum $200,000 worth of third-party liability coverage in Ontario. That constrains those circumstances under which an insurer can therefore cancel the coverage. Statutory condition number 8 sets out the procedure. Section 12 of the Compulsory Automobile Insurance Act provides that where the contract has been in effect for more than 60 days, the insurer may only terminate the contract under statutory condition 8 for one of 4 enumerated reasons: non-payment of the premium, where it's found out the insured gave false particulars of the automobile, the insured knowingly misrepresented any fact required to be disclosed, or a material change in risk. The scheme for cancellation of the policy is straightforward, but it is remarkable how many times it appears to have not been done properly by the insurer. Basically, you have to give 15 days written notice by registered mail to the address that you have for the insured. You have to accompany that with a check refunding the prorated portion of the premium. Many of us have seen files where perhaps a relatively junior person in the claims or underwriting department has sent off a letter to the insured purporting to cancel the policy, not following these conditions accurately, and resulting in all sorts of problems later when the insured is of the view that, when the insurer is of the view that it has gotten rid of a risk that it was entitled to get rid of, and the insured is able to say, no, you didn't get rid of me at all. Now, it is, I believe, and suggest a basic tenet of public speaking that you always end your address or your remarks on a high note. I have searched my mind, I admit in vain, as to how Section C would allow me to do that, so I'll simply thank you for your kind attention.
Thank you, Jim, for dealing with a very difficult subject. Now, I'm going to ask John Nelligan and Allan Houston and Peter Webb to join us on the podium to deal with the questions. And while they're doing that, would anyone with any questions bring them up to the head table? The first question is addressed to John Nelligan, and it deals with the case of July and Neal. The question is, in a 3-car motor vehicle accident where one defendant is identified and one defendant is unidentified, how is it possible to know until judgment that the unidentified driver is solely responsible for the accident? Does July and Neal stand for the proposition that where there are 2 defendants, one of which is unidentified, the limitation period for the unidentified vehicle does not begin to run until it is determined that the unidentified vehicle is solely responsible for the accident? John?
Well, this is the problem I have reading that judgment. They don't seem to deal with the proposition squarely. They just seem to put it when you have reasonable or probable grounds, or should have knowledge of reasonable probable grounds, that the unidentified vehicle is solely responsible. Well, with a 1% rule, you've got to have, to my mind, pretty clear and cogent evidence before you come to that conclusion. But it wasn't decided specifically there, and I still think that whenever you feel on the balance of probabilities that that's going to be the ultimate result, that's the point where you've got to join your insurer. So, of course, you get back to the safety rule, when in doubt, sue, and whenever that looks as if if there is a possibility at all of the identified vehicle getting off scot-free, well, then you've got to come in. The difficulty, of course, is that one of the classic defenses in any case is, well, I was made to swing across the road because an unidentified vehicle, which I cannot now describe, whose license plate I did not get, forced me to swerve across the center line or whatever it is. And we know what normally happens to those defenses when you get to trial. And you, I think, just have to assess the probability of that defense being made to stick and make your own decisions. As they said in that case, they've got to be a little bit clear about it, or we just don't know where we stand. Sorry, I can't help more.
Right. Well, there are many unanswerable questions. For example, if a pedestrian is injured and is unconscious for 6 months, but the pedestrian has a spouse, and the spouse retains a lawyer, both the spouse and the lawyer are aware that this vehicle has disappeared. The accident was as a result of an unidentified vehicle. Does their knowledge get imputed to the unconscious person?
Well, I think the section says there's someone acting on his behalf, so it sort of brings his agents into play, doesn't it?
Well, I think that's subject to argument, whether you if you are then the insured person, you are unconscious, are you then stuck with the neglect of those people who are supposed to be close to you? Is there something that imposes some obligation on them?
Well, what about the wife herself, who is going to make a claim on her own behalf? Is she going to be statute barred and you not, which would be an interesting development?
All right. The question has been raised. Al Houston, you made the comment this morning that if you're driving in Mexico, your auto policy, and I believe you're referring to the liability portion of it, was not effective. If you are injured in Ixtapa by a motor vehicle that is uninsured, is the situation different?
You shouldn't be in Ixtapa, that's the first thing. And you shouldn't be a pedestrian at any time. I had a very interesting conversation with a lawyer from Dallas, Texas, who does a lot of this kind of work, and he said to me, they will not recognize your policy over there, but if you have a policy here, particularly our kind of SCF 44 endorsement, you may have protection over here. You may have the right to be indemnified over here. If you don't have, I'm told, and this may not be an answer to your question, they will not recognize any policy issued in the United States or Canada in Mexico. They do a lot of litigating in Texas in respect of accidents that happen in Mexico because the policies are recognized in Texas, and in some way they assume jurisdiction and litigate the cases there. If the question is your coverage good for an accident that happens in Mexico, as you know, the liability section of your insuring agreement is territorially limited to Canada and the United States. So if it happens in Mexico, you don't have that. The question is your SCF 44 available to you when you're in Mexico? There are two schools of thought. My view is that it probably is available to you worldwide, that it's not territorially limited, although there is a section in the SCF 44, if you take a look at it, that says it incorporates all the terms and conditions and so on of the insuring contract, which does territorially limit it. So the short answer to the question is, if you're in Mexico, buy their insurance. It's a criminal offense in Mexico to have an accident. So if you don't have insurance over there, you may not be coming back home to see us. Buy their insurance over there, which will satisfy them. I'm told you can buy it at the border as you're going through. The second thing is that you should pursue your SCF 44 if you get into a jam where you need that kind of thing, if there's an uninsured person who hit you, Wendell, and they'd have to do a lot of damage before the claim would ever get to the amounts for you that would get into the SCF 44.
Well, we don't have to get that high, Allan. We can just deal with the unidentified coverage. And as I see the policy, there's territorial restriction on Section A, but there's nothing on Section B.
I agree with that.
Yeah.
I agree with that.
Thank you.
Very important, and I think that's worldwide, not just Mexico.
Yep.
I think that's wherever you go, and for
I'm
the
not sure that
benefit,
it was intended to be that way, but
I think it was not intended to be that way, but the SCF 42 was not intended to say all the things that we have now decided it does say. So,
I have a question for Mr. Webb, and it concludes, this is an actual case, help me. Does the defense of, this says uninformed consent, but I assumed it means consent, no consent, apply to Section A coverage? For example, a father lets a son drive a car not knowing that the son's license is suspended. B, son will use car to effect a crime. Or C, son injures innocent third party while making a getaway from a crime. The insurer claims consent by the insurer to the son was uninformed, hence no coverage.
I'm not sure I understand that question, but for the father to be prejudiced by the actions of his son in breach, for example, of a statutory condition, I can't give you the exact wording without reading it, but the father has to paraphrase it, connive in the act of the driver who breached the condition. If he did not, then his coverage as under the statute as owner is unimpaired, even though there may have been a clear breach by the driver. I hope that answers the question, but I'm not certain that it does.
All right, another question for Mr. Webb. The car A making a left turn across the path of car B and loses control on the ice and stops in the path of car B. Car B loses control on the ice and hits stopped car A. Passenger in car B is injured. Who pays the passenger's accident benefits and who pays the injury claim? There's a dispute between car A and B insurers as to who is responsible.
Well, the no-fault benefits are paid by the insurers of the car in which the person was an occupant. The Section A payment will come from the insurer of the driver who was at fault in that circumstance, or maybe from both of them if they were both at fault.
If a car spins out of control and a passenger is thrown out onto the highway, slides across the highway and hits a pole, I've got lots of cases.
Opposed to an Italian, you mean?
And the passenger does not own a car nor is he a dependent relative of anyone with insurance. Is he entitled to any coverage under the accident benefits of the car in which he was a passenger? Peter, you...
No, the reason Houston hasn't got a top drawer in his desk keep the auto policy is because his partners thought he'd probably pull it out the next time he had a wrongful dismissal action. So I think we'll pass that question to him.
Did this happen in Michigan or Ontario?
Well,
I don't think
I didn't want to pass any questions on
I don't
that.
think
It
there's
might
any
go on
question.
For 4 years.
Is the vehicle that was skidding around on the road insured, Mr. Wigle?
Yes.
I think that policy will respond then.
leaving aside the liability portion of it, is that person insured for the purpose of either accident benefits or the
I believe that's arising from the use and operation of that motor vehicle, even though they went out the door and went across the street and hit a Czechoslovakian person or whatever it was you said he hit. I think that
the issue is whether or not he's still an occupant.
yes, that's the issue.
So that if he's thrown out while an occupant, he's still insured under that car.
Yes, the question of whether he's still an occupant is very clear in Ontario, Mr. Wigle. He's still an occupant until he runs into this Italian.
No, he hits a pole. Now,
It's a pole. You see, I could never get the facts straight in these. I believe that he is still an occupant of the vehicle
All right.
while the whole flow is going on, and if you have the other side, I'll beat you.
Well, before he comes to rest, what if he gets hit by an unidentified vehicle?
He's probably going to have very serious injuries. We don't allow those kind of
Or an
accidents to
identified
happen in
vehicle.
Windsor.
Jim, do you have any comment on that situation as to what coverage would apply? Assume the first situation.
Well, that is actually specified. The IBC have guidelines for pedestrians and how they're treated under accident benefit policy. So if you have an insurer that subscribes to the guidelines, not all of them do, then that would be covered. And Mr. Houston's answer is correct.
But what if he is struck while he's spinning out on the road, is struck by a car? Is he covered under both policies?
Well, you can only recover one benefit, but whether it's one policy or the other, it would be specified in those guidelines. I don't have them handy. But
Right.
I would think the
situation
guy
is-
that's-
Aside from the guidelines, is he still an occupant?
Yeah. The guy
Or
who
is
started
he-
the process, the guy who shouldn't have been skidding in the first place in the manner which you described, and he pays it all.
All right, so you get back into the situation where do you look for the causative force or do you look for the direct force when you're seeking out whether or not someone's an insured? Because if you're struck by, then you're an insured. If you're an occupant, you're an insured. So
We don't want to discuss this anymore, Wendell.
Thank you.
it's hard to carry on a conversation with Allan, and you can reach your own conclusions why. Jim Flaherty. This is an example, SEF 44. A is injured in a motor vehicle accident caused by B. A has SEF, I guess it's 44, $500,000. B has Section A, third-party coverage, $200,000. A's damages are $1 million. A is a dependent relative of someone with an SEF 44 of $500,000. What does A recover and from whom? Do you want some time for that?
I'd like to hear it again.
All right. A's injured by B's car. A has an SEF $500,000, SEF 44. B has Section A limits of $200,000. And A's damages are assessed at $1 million. A is also a dependent relative of someone with an SEF 44 of $500,000. How much does A get? I assume that we agree he gets $200,000 under B's Section A coverage. The question is, how much does he get under SEF 44?
I guess
And does he get anything from the second SEF 44?
As long as it's excess, it's taxed to the limit. No, wait a minute, that's only a $500,000, yeah, 44. No, he's only gonna get 2 and 3 because the second SEF 44 does not exceed the other two. Yeah, I think, we're just having a little discussion about it up here.
Should we play the Jeopardy theme song while they work
I
on
think
it?
if you can share your thoughts with us, Jim, we'll give you a disclaimer so there's no liability.
The problem here is that the total of the available SEF 44 and the Section A coverage is $700,000, which exceeds the second SEF 44 of $500,000. So
Well,
that there's more coverage available before you have recourse to that last 44.
well, I guess the question is, there are two $500,000 SEF 44 policies. There's a $200,000 liability policy. There's $1 million damage. Do you end up getting $1 million? Or do you end up getting 500,000, or do you end up getting 700,000?
500,000.
So between the liability and the SAF 44, the total recovery is $500,000.
That's right, because the second additional SEF 44 is excess to the first SEF 44.
And once you get up to your the top of the glass of water, it's 500,000, and that's it.
Yes, I think that's right.
500 plus 2, is that?
No, difference.
No.
2 plus 3.
Yeah.
Now, this question is directed to the defense bar. I guess we should really ask Jim Cameron to comment about this, and then we can. What is the current attitude of the industry concerning seeking recovery from an insured after a judgment in a non-waiver situation? Any general guidelines for counsel acting for such a person?
Well, it's so rare that you recover on such a judgment that I think most insurers would not even attempt it, unless the insurer does have assets. And that is, as I say, that happens so rarely that if he does, we're going to go after him. There's no question.
John Nelligan, do you have any advice for a counsel acting for an insured who signed a non-waiver agreement and judgment has gone against him?
Advice on non-insurer agreement, non-waiver agreements depend on the facts of the case. You have to.
Okay. Well, we'd like to help you, but you'll have to consult John individually on that score. There's a question for Jim Keaney. And it's a claim for actual cash value under Section C, which are litigated. Why are solicitors for the insured so reluctant to use the appraisal procedure under Section 105 of the Insurance Act? Can you respond to that, having had some experience under the appraisal section?
Probably because most people aren't aware of it. It's buried in the small print there. We all are, in effect, products of what we do and what we've been doing over time. And when you get in a claim of that sort, you don't think about remedies or alternatives that you're unfamiliar with, and you simply press on. But there's no good reason to not proceed in that fashion. It may well be a far more benefit to your client. It's less expensive. It is, however, somewhat less predictable. The appraisal procedure I was involved in that Wendell was referring to was a fire loss case, and the outcome there was both surprising and devastating, and it certainly gave me cold feet about that procedure in any other format. But there's no real reason why it can't be made use of in these sorts of cases.
Jim Cameron, do you have any comment about that?
No.
It's cumbersome and laborious to go through that procedure, and it may not be very satisfactory.
Wendell, can I speak?
Yes.
If we're talking about other than auto policy, I have
Well,
one
we're
now.
talking about auto at the moment.
Well,
but it's
I
the
don't know
same
anything
thing.
about auto, so about
Yeah.
that. But I have one now where I represent the insurer, and we've been sued in respect of a fire loss, and we've elected to put an arbitrator in place, and it's not an arbitrator under the fire policy. It's called an umpire, not a. What is the process in a fire policy?
Well, there's a difference between
Appraisal
an
system.
appraisal and an arbitration.
it just may be worth noting that I appointed our nominee, and the other side, the plaintiff, did not. And we had to address the question of what we do about that now. And I was told by one of the juniors in our firm that what you do is you bring an application to stay the plaintiff's action until he appoints someone as their nominee. And there's a case that does that, and the whole thing stops until the process is done, even though there's issues like arson involved and overstating value of claims and lots of issues not related actually to the damages. And that's the some kind of Salima Lumber Company case. Very good of me to remember that. That's 9 years ago, and I was also told that it was my case and I had argued it. I just had forgotten about it. I just wanted to say that, Wendell. Thank you very much.
I wish you had forgotten about it. Anyway, there is a question for Ted Racklin, who isn't here, but the same question was asked 2 or 3 times, and I'll address this to anyone on the panel who will volunteer the answer. As plaintiff's counsel, should I advise my clients to apply for unemployment insurance benefits and no-fault wage loss as soon as possible? And a similar question, is an injured plaintiff required to apply for UIC benefits? And if so, are they deductible, or what if they don't apply? Jim Cameron, are you?
Yeah, I think I can approach that one. The answer is by all means yes. Tell him to apply, or tell him or her to apply for both UIC and the accident benefits. In fact, the accident benefit insurer is, in some cases, some insurers insist that your client apply for any benefits that he may be entitled to under UIC, and will deduct what he would otherwise be entitled to from the benefit. So you end up with a reduced accident benefit. And the second part of the question?
Well, I think that the question is whether they're deductible.
Yes, they are deductible, so that answers the second part of the question.
If you don't claim them, are they still deductible?
Well, I think the insurer will certainly try to deduct them if you don't claim them. Whether you're ultimately successful really is a question of negotiation and or litigation.
Yeah. Well, assuming that you're not successful in persuading them to claim UIC benefits and you deduct them, what is the result in litigation? Jim Flaherty, do you know the answer to that? Al Houston?
I think you have to deduct them.
Whether you
I don't
get them
know
or
that you
not.
have to pursue them, because it's not other insurance, but it's other benefits, isn't it?
I think it's other benefits to which they would otherwise be entitled. And that's
I think
where
what you do is you issue a small claims court for them not paying that, and you sue them in bad faith to pick up the difference.
Does the same consideration apply to workers' compensation benefits?
There's a prohibition, as I understand in the Act, that if workers' compensation is available to you, then no fault is not. Am I
Right.
not correct in that?
That's correct,
You're
yes.
quite
that's
correct about that, but the question is the interpretation of that. Peter Webb, do you have any comment about that? That is the famous case of Chew and Medill.
Right.
Go ahead.
Answers it. It is a prohibition again. It does preclude you from obtaining your no-fault benefits if workers' comp is available to the claimant, period, whether he claims it or not.
But there is an issue as to whether or not they're available. That is, the onus is on the insurer to prove they were available.
I believe that, so yes.
Yeah, but that's where the things get hung up. I think that if there's an issue about their availability, you have to in some way get a hearing to determine that they were available.
Are you saying you think you need a hearing before a tribunal at the WCB, or the court will determine that?
Well, you may have to have one before the WCB unless you're prepared to prove it at trial, and I don't think that the trial judge necessarily can be the arbiter of that, because it's the board that determines. Now,
But you could really, Wendell, you could really do that on a summary kind of an application, couldn't you, to the Workers' Compensation Board? And if you got a denial, then you could go to your no-fault people and say, I'm not entitled to those benefits, so I'm entitled to no fault.
that's right.
You could do that, although I think in practice what happens if you do have recovery from a tortfeasor, you merely accept the denial of the accident benefits given because your client was entitled to workers' compensation benefits, and you proceed and recover from the tortfeasor. So, in practice, that doesn't really happen that often.
Well, then you run into another section, Section 237, which says if these benefits were available, that is, if your no-fault benefits were available, they get deducted. And if workers' compensation isn't available, then you get into the same availability issue. There's a question, another question that really I think is partly Peter Webb and partly Ted Racklin, but I will ask for anyone for volunteers. In a case where a garage man drives a customer's car without her consent, I think this is somebody's case, on a Sunday, no test drive was needed, and in fact, repairs had not yet been started. The garage man owns the shop, has no liability coverage. He rear-ends a third party, causing property damage and bodily injury. Do the insurers of the customer's car pay the BI and PD, or does the uninsured motorist coverage come in effect for the third party? If the third party solicitor names all parties, demands defense is filed, who pays the costs? Am I correct in saying that the third party's uninsured motorist coverage pays? Now, let's go back. The garage man drives a customer's car without her consent. And apparently the car is there having repairs done. The garage man owns the shop, has no liability coverage. He rear-ends a third party, causing bodily injury and property damage. Do the insurers of the customer's car pay, or does the uninsured motorist coverage of the injured party pay? That's the first question. Peter, can you address that?
Well, the question contains the answer. If it is correct that the garage man was driving the car without consent, then there is no statutory liability on the part of the owner, and nothing for the owner's insurers, no one for the owner's insurers to indemnify, because one, they will not indemnify a person driving without consent, and in any case, they will not indemnify a garage man, which is expressly excluded in the policy. So the injured person would have nowhere to look but his own uninsured motorist coverage.
And Section C of Section 3 of the general provisions of the injured party's policy would not come into play.
Right.
The lack of consent would only apply to a vehicle on which he was a passenger or an occupant.
Right.
If the injured party was a passenger in the car driven by the garage man, it's unlikely, I would think, that he's entitled to coverage under his own policy because the vehicle was being operated without consent.
Well, I guess it's absolutely certain since
Yep.
the Coombs decision a few weeks ago.
Right.
Well, that'd be an interesting variation there. The typical case of the child in the back of the car while mother runs into the shop and the car is then stolen by the thief is the child, who is covered normally by the policy as a part of the household, covered as an occupant of the vehicle.
I'm sorry, in this situation where the...
In this situation, the car is stolen with the child in the back seat, sleeping, and is injured as a result of the activity of the thief in his mother's insured vehicle.
Well, I would think that Coombs and Lavelle covers that.
Well, I'm afraid it does, John. It's hard law in those circumstances.
No difference, Jim, Flaherty, and the SEF 44?
But that child's injury is not without recourse. The fund would still pay that claim.
Yeah.
The Motor Vehicle Accident Claims Fund would still pay that claim.
Now, the question goes on, if the third-party solicitor names all the parties, demands defense is filed, who pays the costs? And I can only respond to that by saying that, well, Peter, perhaps you could respond to that. Only people with money end up paying the costs. And if there's, go ahead, Peter.
Well, this is still the case of the garage man who's driving without consent?
Correct.
Well, if everyone is sued and we have decided that the injured person's uninsured carrier is the one who has to pay eventually the damages, then if that uninsured carrier keeps everyone else in the action in the hope of escaping, then he's going to end up paying, I guess, everyone else's costs.
Okay.
As well, if we're dealing with a case where we're talking about, as Al said, there still might ultimately be recourse to the fund in the other scenario. The fund will require that the action be taken against anyone else who that you sue everyone who you might be able to sue before you get any recourse to the fund.
This is a question that perhaps Jim Cameron might respond to, and perhaps John Nelligan. Under Section B coverage, does a self-employed person need to obtain a statement from his accountant in order to substantiate his income? What is the best way to complete the employer's report in such a case?
Yeah, that's a situation that most insurers run into quite frequently, and probably the short answer is to have his accountant complete it rather than he himself completing it as the employer. You're almost always going to run into problems, I think, documenting a wage loss in those circumstances with the insurer. So it requires some careful preparation on the part of the accountant. You'll need it anyway for your tort claim if you have a third-party claim as well.
John, do you have any comment?
I think the proof is exactly the same as in the third-party claim. You just deal with it the same way.
And in a similar vein, what if an injured plaintiff was on a workers' compensation pension at the time of the accident? He's on a 10% pension with part-time earnings. What about no-fault benefits? Is the weekly benefit calculation based on 80% of the total weekly income? That is the pension plus wages. Is the entitlement 80% of the pension or 80% of the wages plus pension? As I assume that the question presupposes, of course, that he's got another job, but he's getting a partial pension.
I would think the wages are not inclusive of the pension. I think the pension is not wages. It's some arrangement made with somebody to pay you on an ongoing basis, not wages.
Right. I
would argue that it's 80% of the actual dollars paid for wages during the week that you're talking about.
I think that's the argument that I would, as an insurer, use, and also relying on the section of the policy which deducts from that calculation. It's Part B, Part 2, 2B, amount of weekly payment, and it deducts any payments for loss of income from employment available or received by such person under the laws of any jurisdiction, and we would quote that section and deduct the pension.
All right. Well, one last question. If a claimant is injured and it's an uninsured loss, can the insured get the statutory minimum limits under the uninsured portion of the policy and then turn to his SEF 44 if his judgment exceeds $200,000. Jim Flaherty, I gather that question is for you.
Yes. That's section 4B where you, in doing the calculation, you would deduct the amount received from the uninsured carrier from the SEF 44 limit and arrive at a difference, which would be the amount payable by the SEF 44 insurer, less any other funds actually received. But the uninsured payments are specifically included in section 4B of SEF 44.
On behalf of the panel, I'd like to thank you for staying. I hope that you found some of the responses of help. I hope they've been stimulating for you. Would you please leave at the desk your evaluation forms